Welcome back to Mama to Two Howeries. This video is going to go over motions in law. What are they and what do they mean? We're going to break down the meaning of most of the motions, but not all. These are going to be some that we've seen in a case that has been really big in the world of celebrity news. So join me in going into this video. Motion to strike. A motion to strike is a legal motion given by one party requesting the presiding judge order for removal of all or part of the other party's pleading to the court. It is a request for judge's order to remove, eliminate, or make immaterial certain or entire proportions of the opponent's legal pleading on one of several grounds. It is often used as an attempt to have an entire clause of action stricken from the court of record. This can be either oral or written, but only under certain stated reasons. Thirdly, a motion to strike is also made orally during a trial to ask the judge to strike down the answer made by a witness in violation of the rules of evidence. If the motion is accepted, the jury must ignore those stricken parts. According to Rule 12.4f of the Federal Rule of Civil Procedure, states that the court may either on its own or on a motion made by a party strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. So going into asking for a strike. The most common one everybody kind of knows about is, let's say the lawyer asks you a yes or no question, and then you say yes, but blah blah blah, or yes and blah blah blah. And so usually what you'll find is that they will accept yes, and then they will motion to strike anything after what was said after yes. And it does get stricken from the record, and the jury is supposed to ignore it. But if the jury's already heard it, it's hard to ignore. Now, if for some reason they don't remember and they ask to look at the transcript, that motion to strike where those parts were stricken, those parts will not be in the transcript. So it means it's like it didn't even exist, because it was not an okay thing to do. So that's the one that most people are familiar with. Now, another one is and let's go with Depp v. Heard, if a party's putting forth a motion, a frivolous motion, meaning it has no merit, it is just absolute nonsense, and it should not even be entertained, and the lawyer that wrote this motion knew that it was nonsense and frivolous and that it's not a good idea, but they decided to do it anyways, which is wasting the court's time and so on. And so usually the other team's lawyers respond to this motion, and usually they will put in a motion to strike, and they will list all the reasons. So in the Depp v. Heard one, there is a motion for mistrial or a new trial because of a fake juror, this juror 15. He supposedly, on paper, is supposed to be born in 1945, but his date of birth is actually 1970. And so they wanted the investigation and why this person shouldn't have ended up here and everything else. Well, the thing is she had a paper that had the list of jurors. In Virginia's rules, it states that it is the attorney's job to look into and verify that this information is correct. And as soon as you see that it is not correct, you should be bringing it up at that time that you realize it. And so I don't think it's going to be a very successful motion for a new trial. But in the motion to strike, and their respondent to that is Heard's team had the list for 5 days prior to the trial. She knew that the birth date was wrong, and she waited until after 7 weeks of the court's time and money to bring this up. And she also had a chance during voir dire to ask questions and request removal of said juror. But she didn't. She accepted this juror after questioning, after looking him in the face, where it should have been very obvious that the juror was not born in 1945. Well, yes, that may seem like a big deal. It's found out that the summons was sent to that juror's house, and that juror has the same name as his father. So when the summons came in, the son thought it was his, because it went to that same address. It had his name on it. Like, it's not just somebody coming in off the street. It's not a rando. And came in for jury duty. So what Heard's team has to prove in order to get this new trial is that it was prejudicial. And how was this jury, the son instead of the father, prejudice against Heard? And that can't be done because 6 other ones agree. And if it was, how is it prejudice to you, and how is it not prejudice to Depp? Why is it only prejudicial one way? And so Depp's team put in a motion to strike this ridiculous motion about the juror. It needs to be stricken from the record. It is ridiculous. And this is not okay. So that is like a written motion to strike based off of that. So we've got the one that everybody knows about, where they're in court and they do it, and then an example of a written one after an opponent's pleading for things. So you can let me know what you think about all of that. Motion to dismiss, or what a lot of people like to refer to it as throwing the case out. The moving party in such a case may concede the facts of the case are true, but that the case should not nonetheless be dismissed because there is no legal issue presented in those facts that the court can rule on. The motion helps to ensure that disputes that involve no legal issue do not end up wasting the court's time and resources. In some cases, there may even be a legal issue at stake, but the statute of limitations has expired, meaning the court can no longer deliver a verdict. Additionally, a motion to dismiss may be filed in the defendant waives his or her right to a speedy trial, has been granted immunity or a pardon, or if that defendant had been previously tried for the same offense, which is known as double jeopardy. So, in talking about this case of Depp v. Heard, Elaine likes to point out that Johnny and Amber have already tried this case. It's the same offense, and you can't try to sue again. And while we know that that is not true, so for that argument, the motion to dismiss on that particular argument would be denied. And we don't have a statute of limitations here in this particular case, so they can still deliver a verdict. And I think that's why criminal charges and things like that, I think it is past the statute of limitations, so Johnny can't go after Amber criminally because the time has already lapsed. And so this is the only way he can go about it. Does it stink when that happens? Yes. But the purpose is so that people can't just wait and wait and wait and wait to just file things out. You can't go 10 years later and be like, oh yeah, I want to do this on a lot of things. Now, there are several things that has no statute of limitations, and that it doesn't matter how much time has gone by. Those are usually for more serious things, though. So, also, kind of that goes with motion to dismiss. There is a motion for summary judgment. Now, a motion for summary judgment and a motion to dismiss are often confused with one another. They are not the same thing. A motion to dismiss results in the case being thrown out altogether, and that no verdict is going to be issued. Where summary judgment, there will be a verdict. but it's not the and so the case isn't thrown out. It's going to be, this is the case. We're going to have a summary judgment, and that's going to be it. There's no going past summary judgment. And so Depp v. Heard did not have a summary judgment, which is why it made it to trial. Now, a motion for directed verdict is a motion asking the court to issue a direct verdict. This motion is made before a case is submitted to the jury. It argues that no reasonable jury could find for the opposition party, and the plaintiff or the defendant may make this motion. So, in a motion for directed verdict, this happens after the trial has been done, has been fully heard, but before we start to give jury instructions and send the jury to deliberate and actually hand them this case to start deliberations. This is where this motion for directed verdict is going to be had. And this did not happen in this case either. There was, and even if it had, I think that Judge A would have denied it. And because in this, it's very clear that the jury is the fact finders. And so Judge A denied many motions to dismiss, in the beginning, after Johnny's team rested its case, and then after Amber's team rested their defense. They all each had times to try to throw the case out to where it doesn't go any further, and there isn't enough evidence to even allow a jury to decide anything. But in Depp v. Heard, all motions to dismiss were denied. Next up, we have discovery motions. And it is a collection of information and evidence that can then use to build plaintiff or defendant's cases. Its efforts is to discover all the facts of the case. Both parties can request information from one another to help establish the facts of the case that they are trying. Different motions can be used to ensure that both parties are able to handle the discovery process to the best of their abilities. If one party fails to respond to a request for information, for example, then a motion to compel discovery of that information could force the party to provide a response. Motion to compel discovery can be used if the party responds to the request for information, but its response is vague or incomplete, and failing to comply with either of the motions, if they are granted, could result in the offending party being held in contempt. So, when making a motion to compel, the moving party asks the judge to use the power of the court to essentially force another party to do something that he or she has so far refused to do. As noted, motions to compel can be used during the discovery process to ensure that both parties have full access to the facts of the case. So, one instance that we have in discovery motions, we have motion to compel for Amber to hand over all of her devices so that pictures, videos, texts, any information that's on those that relates to this case can be given to Johnny's side. And they did file a motion to compel. Amber's Heard ended up being sanctioned for this because they did not provide this. There was also one that was compelling the ACLU to give the information about the donations. And also, it was showing that there was drafts before the final op-ed. And so without that motion to compel, a lot of the donate and pledge conversation would not have made it into this trial, which was a huge deal. And it is part of the reason that Johnny lost against the son in the UK case. It's because the ACLU in the UK was not compelled to hand over the discovery about the donations. And also we have a motion for nolle prosequi, which literally means that the prosecution has decided not to prosecute. So some people call it motion for nolle, but it just means that through the discovery process, either evidence came out that maybe proved that a specific party did not actually do the thing, and the prosecution or the plaintiff is going to drop charges, the case, because they no longer have enough information or evidence to back up the claims that they were trying to make in the case. So those are some things that go on through discovery motions. Motion to reopen proofs. We have to have that negative ruling on a case. The same case judge will be the one who grants or denies the motion. So in Depp v. Heard had the negative ruling on the case, so she can motion to reopen proofs, and Judge A will be the one granting or denying this motion of Heard's team. Then we have, you can file for a motion to reopen proofs to ask the courts to re-examine a case after no more than 60 days from when final judgment was entered. So final judgment was entered on June 24th, 2022. 60 days from that would be August 24th, 2022. So it must be filed by or before August 24th, which they have already done in filing this, because I believe this was filed the 1st of July, which is only 7 days, so they are well within that amount of time. And the success of the motion, for this to happen, there needs to be new evidence discovered after the conclusion of the case. The new evidence will be heard by the same judge who can render an updated verdict. So basically what they're wanting to have done with this motion is they want the judge to relook at everything and say, okay, I'm going to update this verdict, and I am going to say that the original verdict was wrong that came from the jury. And so now I'm going to change the verdict to go with what I say, because I find that there was an issue. That is what Heard's team would like to happen. I do not think that that will happen, and I don't think that there's any new evidence that would make it to where they can reopen any of this stuff. So I do not think that there will be an updated verdict. The verdict will stand. And so this motion, I believe, is going to be denied. All right, moving on to motion to reconsider. It can happen after a negative ruling on the case, after no more than 15 days from within final judgment was entered. So in the Depp v. Heard case, the court entered the motion of final judgment on June 24th, 2022, and 6 days after the final judgment was entered on July 1st, 2022 is when the motion was filed. It'll be the same case judge that was who had been dealing with the case. So in the Depp v. Heard, it will be Judge Ascarati, and she will be the one who is going to grant or deny the motion to reconsider. You can file for a motion to reconsider to ask the court saying that there was a legal error in judgment. Success of a motion, there needs to be merit in your arguments to support claims in the motion, and must provide legal arguments based upon prior precedent. So on a motion to reconsider, you will not get it granted just because you do not like the outcome. Because whoever loses isn't going to like the outcome. And we can't just be filing motions all the time because you don't like the outcome and you're upset with it. It has to be a legal error. Was there something that the judge did that made it to where the losing party could have won based on this error in judgment made by the courts? And it's usually done before somebody goes to appeal, because they want to see if the judge that heard the case will change it. And if they won't, usually they go to the appeal process. Was there a legal judgment an illegal error on evidence kept out? Should something have come in and it didn't, and that was a legal error in judgment? That's one thing that Heard's team has said, that their therapist notes should say this, or the UK trial. The jurors shouldn't have known about the UK trial, or we shouldn't even have had this trial because we already had this trial in the UK, which is not true, because Amber and Johnny were not parties to the UK trial against each other. It was Johnny and the son, and it was on a different article. So it has no reason to come in. Therapist notes are hearsay. We will have another video on that soon, going over through the different forms of hearsay. Or another one they've kind of brought up is this juror whose birthday says is born in 1945, but the one that was on the juror was born in 1970. But all of those, most of those are not, they're not going to be granted on this particular one, because you have to show where those things really, really harmed your case, and with these things coming in, or with this other juror not on the panel, that it would have changed the case entirely. And if it doesn't go to those standards, usually your motion to reconsider is going to be denied. So those are some important things that you need to realize on motion to reconsider. Motion to set aside. This is a motion that is a request for the court to nullify or vacate a judgment or verdict that had been previously reached in the case. So in Depp v. Heard, the reason that Heard's team wants the judge to vacate and nullify the judgment is because they think that the UK trial did it. And as I stated in the previous slide, that is not true. So that one's X'd out for their chance to set aside. But also, the aggrieved party must specify the mistakes, legal errors, or other factors of the first trial that justify the party's redress. So in their motion, they do specify that it should have come in. This case shouldn't have happened. And so because it did, it needs to be nullified or vacated. And then there's also things about they couldn't get, there's not a reason that the jurors could find this award for Depp in the 10.35 and Heard for the 2. And so because Heard's team does not see how they both can basically win something on their side, and in her mind it means, oh, they found that Amber abused Johnny and that Johnny abused Amber. Well, that is not correct, because the only claim that Amber won on was the second claim that talked about calling the cops. They came, did not work, so they roughed it up, spilt a little wine, and called the cops again. And then in the trial, that was not shown that that was the order of things happening. And in the body camera, it didn't show the wine spills. So it was basically saying that that order did not happen, or the fact that it said that it was Amber and her friends, so maybe they just didn't think the friends needed to be involved in it, and it was just Amber, or they didn't think that any of them did things in the order that they said. Nowhere in the one that she won does it say that they believe that Amber is a victim. It just does not say that. Everything else that would state that, the jurors said, you were not abused. This was made up. This was a hoax. You did things with malice, actual malice. It was false on all the abuse parts. It's just the very detailed statement that explains orders. So that's one of the reasons they want things set aside too. I don't think they have a legal standing on that as either, so that one's out. Generally filed if new evidence comes to light after the case has ended that may cast doubt on the original verdict. And on Depp v. Heard, they are bringing up this juror that has come to light that he was the wrong person because he clearly was not 77. He was much younger. But in other things that we find out afterwards is that wasn't new. That wasn't something that you figured out after the trial and things were considered. You knew that before the trial and when the trial was going on. So you do not get anything granted on that motion. Another one was the judgment was obtained by fraud. I do not believe that happened. Maybe they consider the fraud the juror thing, but it doesn't look like it was a fraudulent thing. It looks like his name was on it, his address was on it. It was just a difference in a father and a son's birth date. That's it. It's not just some weird thing that happened. It was not a malicious thing and a willful act to commit fraud in this happening. The other one is a unique aspect of a motion to set aside judgment is that it can be filed long after a verdict or judgment has been issued, even years afterwards. So, if something does come out, even years from now, about this case that could have changed this case, that nobody could have figured out during the trial, you can file for a motion to set aside. So it doesn't seem like there is a time limit like there is on a lot of other motions. Well, so it can definitely be past 15 days, 30 days, 60 days. Statutes of limitations on going after somebody. It looks like this one doesn't really have a timeline on it. So that is a motion to set aside. Let me know if you think the motion to set aside in the Depp v. Heard case will be granted. And what is your opinions on it? Let me know in the comments. Next, we have motion for a new trial. We're going to go through these and then we're going to kind of explain some of the stuff that goes with this and the examples that we have in the Depp v. Heard case. This motion is filed after a verdict has been delivered. Either party can make a motion for a new trial if they believe that significant error was made during the trial that makes it necessary for them to be granted a new trial. The grounds for granting the motion for a new trial include a significant error of law, verdict going against the weight of the evidence, irregularity in court proceedings, jury misconduct, newly discovered material evidence, and improper damages. In response to a motion for a new trial for either insufficient or excessive damages, a court may order remediature or abdicature to avoid holding a new trial. In many jurisdictions, a party must move for a new trial in order to raise the issue on appeal. Often a motion for a new trial is made together with a motion for judgment as a matter of law, JMOL, or a judgment notwithstanding the verdict, JNOV. Now, a JNOV, a judgment notwithstanding the verdict, is a judgment by the trial judge after a jury has issued a verdict to set aside the jury's verdict and enter a judgment in favor of the losing party without a new trial. The Latin equivalent judgment, non obstante verdicto, and then we have judgment as a matter of law, JMOL. This motion is made before a case is submitted to the jury. It argues that no reasonable juror could find for the opposing party. Is an example, whatever evidence exists for such ruling is legally insufficient. So, in this, the judgment notwithstanding the verdict is filed after a final verdict has been lifted after the trial, and a judgment as a matter of law is before the jury gets it. So, before the court says, okay, you have seen and heard all of the evidence, we are going to hand it to you. You are going to make the decision as the fact finders on damages and whether you believe that this was done by this party or you believe that this was correct on this other party. And so before it all gets handed over to the jury, that is when the motion for judgment as a matter of law comes in. If you do not do that, judgment as a matter of law is not going to come in really. And then the notwithstanding a verdict is Heard is wanting Judge A to say, oh, you're right, you shouldn't have lost your case. Here, I'll change it and make it to where Depp loses and you win. But in order for that to happen, you have to have a lot of stuff to say that everyone needs to waste more time and more money after we've gone through a whole entire trial based on things that you think happened that would make it to where this trial was not fair. It did not have due process. Everything needs to be completely redone. It takes a lot for a motion for a new trial to be granted. And so Heard's team has tried to say that Depp didn't have enough information. He had no evidence. So he shouldn't have won. There was a jury that was said to be born in 1945, but was born in 1970. There's no newly discovered material. And improper damages. $10.35 million in damages is not going to be considered improper or excessive when you're asked for 50 and he's only getting a little over 10. Or saying that $2 million for Heard is insufficient because they want to look at it differently. But they also have to give it their all and push for a new trial or push for the verdict to be set aside, change a damage or change the ruling of it so that nobody actually has to go through a new trial. But they have to file the motion for a new trial and have it get denied in order for them to say, here, appellate court, we're appealing this because of this, 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 and this. We tried to get a motion for a new trial or to get the verdict set aside. All of that. And we were not successful in getting those motions granted. So we want you to look at all of this, and we need you, appellate court, to say that, yes, we deserve a new trial. So they have to make these motions, and that's a part of just fighting for their client. And even though a lot of us think that there is no merit to it, in this particular case, she's still going to attempt and give it a shot in hopes that it will get granted. So that is everything on a motion for a new trial. Motion to appeal. It has to have the negative ruling on the case, which it will. More than likely, because I think any chance of doing anything with the final judgment entered, I don't think there's been anything that Heard has presented to suggest that that's any of that stuff is going to be granted. So the motion to appeal. Now, it is going to be looked at by an appellate court rather than the same judge. You have no later than 30 days from the date of final judgment was entered. Payment of all fees and the taking all steps provided in rules to cause a copy for the petition of appeal to be served. In Depp v. Heard, they have until July 24th, which is coming up soon, to file a motion for appeal. They also will need to put up the whole judgment plus 6% for a year. And so she's going to have to put up the 10.35 million and 6% of that before she can appeal. And this all needs to be done by July 24th. And we're sitting at July 12th. Not many days left. Also, the petition of the appeal must designate the regulation or case decision appealed from, specifying the errors assigned. You need to state the reasons why the regulation or the case decision was unlawful and conclude with specific statement of the relief requested. So, is there something that was unlawful that happened? I do not believe so. If there was, you need to say what it was. They're going to bring up the juror. I don't think that's going to fall under unlawful because they had a chance to ask him questions and approve him. And they knew about it ahead of time. I do not think the therapist notes or the UK judgment, as they call it, was suppressed, which it wasn't suppressed. One was not relevant to this case, and the other was complete self-reporting hearsay. And what they would like as relief, whether it's the new trial, that Amber doesn't have to pay Johnny, that the verdict needs to be set aside, or it needs to be switched to say that Johnny is liable and Amber is not. Those are going to be the things that they are going to request for their relief. I don't think the appeal is going to be granted either, but we shall see. And we have less than a month to see what their motion to appeal will look like, and if Amber can put up the 10.35 and 6% for the year. So let me know what you think are some things that Amber should put in her appeal. Or if Johnny wanted to file for an appeal on that $2 million, what should he put down? Leave me a comment below. Motion in limine. This concerns what evidence can and cannot be presented to a jury in court. Instead of risking a jury being exposed to prejudicial evidence that can later be found inadmissible, so the evidence is not presented to the jury in the first place. So let's figure out what can and cannot be said. So if you say something cannot be exposed to the jury. You cannot tell them, you cannot show them, you can't anything with it. Do not go near that particular thing. And if it's been ruled that they cannot, and if they try to present it and expose it to the juror, when it's already been said that it is inadmissible and you were told not to bring it in, the opposing party's lawyer will object because of a motion in limine. In other words, we already discovered this. We already talked about it. They were not supposed to bring this up, and they did. And it is not okay, because this is stuff that should not be given to them. And they try to do this before a trial so that there's not as much saying, oh, I moved to admit this, or you start talking about it and some of it's either been shown or heard by the jury, and then it's like, oh no, you can't, that can't be brought in. You cannot talk about that. But that whole, once they've seen it and heard it, it's hard to just ignore it. It's just going to be there. And so to avoid all of that and it end up being fair and a just trial, this is stuff that they do. And I think it helps. I also think it helps save a lot of time as far as when the trial is actually going on, because there would be a lot more objections and sidebars and all of that and dead air basically for the jury if they were doing all of this in front of the court. And it's just a big chaotic mess. So I think it is more organized to do it this way. And so next we have, it helps ensure that the defendant receives a fair trial, which is less assured if the jury is simply told to disregard the evidence that it has already been exposed to. That's what I just talked about. It ensures that the information is not presented to the juror in the first place. And if either party violates the motion in limine, then a mistrial can be declared. So putting up this information that is prejudicial and they're not supposed to see can cause a mistrial. Because if this jury in a case has information that they should not have, and they are going to base decisions off of that information that they should not have, then it needs to restart. And they need to go through a new trial to where the next jury is making a decision without that stuff. So it is very important not to violate motions in limine, because it can cost a lot more money and it can cost a lot more time. And if your party that you're representing has to go and restart trials and things be even pushed back further in time to get it over with, you can almost guarantee that your party that you represent is not going to be happy with you. But moving on to this last part, there are 3 types of motions in limine. Inclusionary, which is being made when the party is asking the court that certain evidence be specifically included in the trial. So inclusionary means you can bring all that in. Exclusionary which is the information that asks that the information be excluded and kept from the jury. That's the one that do not break that part. Most people don't break inclusionary. They do want probably more evidence included that may not be able to be included, but that one's usually okay. The exclusionary is the biggest one that can upset a lot of people. And then preclusionary can prevent potential inadmissible evidence from being included. So if something comes up and it potentially can be inadmissible, depending on how it's coming in, if you didn't lay a foundation for it to come in, and certain things like that, or witnesses can't come in because you didn't have them put in and under certain things. And so a lot of those things can be inadmissible. An example of this is the exes coming into the Depp v. Heard thing. They were not going to bring up any exes. But as soon as Heard said that Depp pushed Kate Moss down the stairs, all bets were off. Because now they can bring in that stuff. They can bring Kate Moss in and say, did this happen? No. But before she said that would have never been brought up. None of that would have come in. And as soon as you deny something that maybe you said previously, an inconsistent statement, well, if you would have admitted to it, you would have been good. But since you didn't, now we can admit it. So it is preclusionary. It is it being something that can be inadmissible, potentially, but it could have a chance at coming in, or it just may not ever come in. It's just going to be, depends on how things are played, whether you're going to be able to use it or not. It's your basically non-guaranteed stack. So you got your yes, your no's, and your maybes. Inclusionary is your yes, exclusionary is your no, and preclusionary is your maybes. So hopefully that breaks that down into a way that you all can understand it on this particular motion.